The courtroom opens with a procedural moment, but the tension is already there. The judge explains that a new attorney, Mr. Jeff, has been appointed to represent Miss Pugh. The judge calmly resets the case, making it clear this is about fairness and giving the defense time to prepare. But listen closely. This isn't just a delay. It's the court trying to prevent a bigger problem down the road. Right from the start, you can sense that Miss Pugh is not satisfied with how things are unfolding.
Right. Perfect. So, Miss Pugh, Mr. Jeffries has been appointed to represent you. He's trying to get caught up real quickly on all the information, the discovery in your case. I'm going to reset your case so that he can get all of that. Once he gets it, he'll be out there to go over it with you, and we'll see if we can get an announcement at the next court date.
Respectfully, Your Honor, I do not agree to comply with any of the appointed court agents, considering that their first duties to the state.
I understand. We've had this conversation before.
Conflict of interest. And for your record, I'll be representing myself.
So if you want to represent yourself, there's some things. Ms. Pugh, stop talking over me. If you want to stop talking over me. If you want to represent yourself, then there is a process that we have to go through, and we'll do that today if that's what you want to do. We'll get your case set for trial, and we'll go forward that way. It is highly inadvisable for you to represent yourself. Lawyers have many, many years of training. They understand the law. They understand how a trial works, because here's what happens. When you're in a trial and you represent yourself, you're expected to know and follow all of the rules of evidence, all the rules of procedure. And so you're really at a disadvantage if you don't know those things. And so you have to do everything just like the assistant district attorney would. And if you don't, you're going to be in front of a jury, and it's going to show, and it's just not going to be, it usually does not work out in your benefit. But I have to go through with you some questions first before we do that. And then if you still want to do that, then there's a couple of options, and we'll go over those as well. Okay. So I am supposed to ask you, I'm going to go through these questions. I need you to answer them if you want to represent yourself, because this is required. All right. So have you ever studied the law? Okay. Have you ever represented yourself before in any kind of criminal matter? Okay. Do you understand the charges against you? Okay. And so do you know, and we've gone over before, I think, what the range of punishment is if you're found guilty on a jury? Do you know what that is? Let's see. Hold on a second. Let me pull you up here. We'll go over that again as well.
This is a critical turning point. The judge explains the punishment range clearly: 2 to 10 years in prison if found guilty. When Miss Pugh says she doesn't understand, the courtroom pauses. That response changes everything. This isn't a minor detail. This is the core consequence of the case. If you don't understand what's at stake, should you really be steering your own defense?
The date of that allegations from June 22nd of 2021. And what that means is if you're found guilty, that the range of punishment that the jury could give you is between 2 years as a minimum punishment up to 10 years in prison, anywhere in between. Do you understand? And did you answer out loud just for the record?
Do I understand?
What do you not understand about that?
I don't understand.
So here's the thing. If you want to represent yourself, by law, you have to be able to understand these things. Otherwise, I've got to appoint an attorney for you. So you can't just say, I want to represent myself because I don't like the attorney or I don't like the process. This is the process that you're in. You live in Texas, you live in the United States. This is the law that applies to your case. So what do you not understand about the range of punishment if you're found guilty? And I'd be glad to explain it. That's what a jury's for, right? And so if you say you're not guilty, then you go in front of a jury and they determine, after they listen to the evidence, if you're guilty or not. That doesn't have anything to do with if they find you guilty, you understanding that they could send you to prison for between 2 years and up to 10 years. Do you understand that part? What are you, yes or no? No, you don't understand that. So, Ms. Pugh, it's my understanding, I'm not going to allow you to represent yourself because you don't understand the law and the process. So we're on question number 4 out of 15 that I'm supposed to ask you. So Mr. Jeffries is going to stay on your case. I don't care what you want at this point. You can't do it. All right, you can go back with the bailiff. I'm done. Go back with the bailiff. Go back with the bailiff. Welcome to the criminal appointment list. This was not meant to be any kind of punishment, I promise. So Mr. Jeffries, get ready like you would. Probably it's going to go straight onto a jury.
I hope so.
We'll just get it figured out that way. All right.
This courtroom exchange highlights the balance between personal rights and legal responsibility. The ruling reinforces that understanding the law isn't optional when freedom is on the line. What do you think? Did the judge make the right call? If you found this breakdown helpful, like the video, share your thoughts in the comments, and subscribe for more courtroom analysis and real legal moments explained clearly.